Dr. Kizza, Besigye and Hajji Lutale returned to the court-martial today for the 6th time since they were first produced in court nearly 2 months ago. They were brought there on charges related to national security and unlawful possession of firearms and ammunition. On Monday, the prosecution introduced an amended charge sheet, slapping the duo with fresh charges of treachery. It also introduced another suspect in Captain Dennis Ola, a serving UPDF officer attached to the Army's Armored Brigade. Dr. Besigye and Lutale declined to plead to the treachery charges on Monday, forcing the court-martial to adjourn to today to rule on the matter. In today's court session, the chairman of the court-martial, Brigadier General Freeman Mugabe, ruled out all objections raised by the defense lawyers.
This court finds that it is not true that Section 208 of the UPDF Act appears to grant jurisdiction, but actually gives jurisdiction to this court to try the accused person. Jurisdiction being a breach of the statute, and this court having addressed itself to the provisions of Article 79 and 129 of the Constitution. This court finds the cited articles not applicable in this application and finds that this court has jurisdiction in the case. Accordingly, the objection raised are hereby dismissed, and the accused person should take plea.
However, the defense lawyers countered by insisting that the court-martial lacked the jurisdiction to try civilians. This move prevented court from administering plea for most of today as defense lawyers and prosecution laid out their respective arguments.
And we contend that in the finding that you have jurisdiction in this matter, the General Court-Martial is putting itself above civilian authority.
However, the prosecution pushed those arguments aside and insisted that there was no legal precedent preventing the court from trying civilians.
Institution of and or giving effect to the orders and declarations issued by the Constitutional Court in the Constitutional Petition number 45 of 2016 between the parties hereto are stayed until disposal of applicants' intended appeal. Who are you to go against the order of the Supreme Court? Chairman and other court members, that is the position of the law. And in case it is not, if we don't proceed, personally, I think I would even be prosecuted to give a reason that we don't have jurisdiction.
Defense lawyers also argued that the court-martial is not independent and that its decisions are made by a party of higher authority outside the court, and asked for the Constitutional Court to intervene.
Military courts are not independent, and that they are military courts of the executive. They belong to the executive. Moreover, the charges they try are brought by the army.
There is nothing in the Constitution that gives the UPDF judicial authority over civilians. And therefore, any act of parliament conferring judicial authority on civilians to the General Court-Martial is unconstitutional. So it's a question the court will have to determine, to declare the UPDF Act unconstitutional to the extent that it confers judicial authority on civilians to the UPDF.
After adjourning court for 1 hour, Brigadier General Freeman Mugabe delivered the uncomfortable news to the defense lawyers, rejecting their request to transfer the case to the Constitutional Court.
This court finds that since most questions raised were decided upon the Court of Appeal, which also sits as a constitutional court, and the matter is on appeal, especially in the Kabazuguruka case, this court declines to make a reference as prayed by counsel for the accused. This court will continue hearing the cases following the order of stay that was given by the Supreme Court, and the application is hereby declined. The accused should take plea.
Attempts of the defense lawyers to persuade court to reverse the decision were futile, as the judge advocate insisted that the ruling was final.
Appearing and the record of proceedings, I advised this court that a ruling you appeal against the final decision of court, and therefore you cannot try to turn out words to convince the chairman. When I advised the court, we went into plea-taking, and we have finished. So the next time is adjourning the next date, and any matter arising, we shall take it from there.
Besigye and Lutale declined to plead to the new charges as per the amended charge sheet, but the court-martial entered the plea of not guilty for both of them. The accused persons have since been remanded to Luzira prisons until 3rd February for further mention.
When we have sought to appeal their ruling, and the law clearly says we have a right of appeal and uses the mandatory language, shall. The court, through the judge advocate, has declined, and even declined to hear our arguments. We are leaving this place very sad, not able to know whether the court is still going to function or it's the judge advocate, because he has totally hijacked.
Daniel Kibet, NTV.